First of all, Minister, can I welcome the publication of this legislation and the fact that we're debating it here at long last. 13 years since the government of the day committed to bring in this piece of legislation. And your predecessor, Minister Dermot Ahern, told me in a parliamentary reply on the 22nd of April in 2009 that unless we reformed the notification process here in this country in tandem with what had been done in the UK, this country, that our jurisdiction would become a safe haven for convicted sex offenders. And sadly, I believe over the last 13 years that has happened. And it's something that I'll return to in a minute. But I think what this legislation will do is close off quite a number of dangerous loopholes that are currently within the existing legislation, particularly in terms of the management and monitoring of high-risk sex offenders, which the law at the moment left that system completely open to abuse, and people that wanted to avoid detection could easily do so. And what this legislation will now do is ensure for the first time in this country we have an actual effective sex offenders register, and I think that is a very positive development. I also believe that the provisions in the legislation to create a legislative basis for the assessment and the management of risk posed by sex offenders, the disclosure of information by An Garda Síochána regarding someone who is on the sex offenders register, and the Gardaí being able to apply for the discharge or the variation of a sex offenders order is welcome. And I would hope that these new powers will ensure that many of those that are convicted of serious sexual offences would actually avail of the treatment and support services that are available within the Irish Prison Service. Because many sex offenders today are rejecting treatment despite the fact that treatment services have actually been expanded. Only 1 in 8 sex offenders actually avail of treatment in prison, even though, as I say, there has been an expansion of the capacity of the treatment services being offered to sex offenders both in Arbour Hill and in the Midland Prison in Laois. And we know from research that availing of those courses reduces the risk of reoffending by 3.5 times. And that's according to the psychology unit within the Irish Prison Service itself. And back in 2009, when the Department of Justice carried out the review of the current legislation into the sentencing, treatment and the monitoring of sex offenders, it recommended making early release of sex offenders conditional on their engagement with the treatment programmes. And I believe, Minister, that this needs to be reflected in this legislation. Such a system is in place in Vermont in the United States, which is one of the benchmark states globally in terms of the management of sex offenders, where sex offenders are not eligible for parole unless they actually have availed of treatment in prison. But I think the key inadequacy in the new law that's before us, while it does provide, and I welcome the fact that it provides the right to information, limited as it is, and we'll deal with this in more detail at committee stage, I think the big weakness in this legislation is that it fails to address both analogue and digital rights to be forgotten by convicted sex offenders. And this is a fundamental weakness in the legislation. And I believe, for the sake of the victims who have to live with the consequences of those perpetrators and any potential future victims, that those convicted of sexual offences should lose the right to be forgotten permanently. Now, there are 2 aspects to this. The first one is in relation to the right to be forgotten online. And we've seen recent press coverage of activities of criminals who are behind multi-million-euro vice rings being forgotten by Google following requests under the EU privacy law. And Google has also delisted news articles relating to convictions for sexual offences, including court reports on men convicted of possessing child sexual abuse material. Now, it's completely unacceptable that court reports are being wiped away online. The whole idea behind our court system is that this takes place in public, that information is available to the public, and here we have these guilty parties now applying for requests and exploiting the privacy laws at the moment, and that cannot and must not be tolerated. Because the operation of the right to be forgotten as a result of the European Court of Justice decision back in 2014, while it established the right to request that internet search engines delist links containing information about them that is inadequate, irrelevant, no longer relevant or excessive. Now, under those 4 tests, Minister, I don't believe that information regarding sexual offenders falls under any of those 4 thresholds and should not be tolerated. And there isn't an absolute right to be forgotten, and it must be balanced against public interest factors. And it is in the public interest that that information remains available to the public, because it is vital information, and we cannot just airbrush away the stories of these victims. It is wrong. It is a further abuse of these victims, and we have to ensure that that will not be tolerated or accepted. Now, Google have defended its handling of the request to delist these articles about criminal convictions for sexual offences and organising prostitution, and said that they're only in compliance with the guidelines set down by the European Commission. And they're doing it based on the amount of time that has passed since the article was first published. Now, that is not an acceptable threshold to be used to actually consider this. There is very relevant, vital information that must remain in the public domain, not only to protect future potential victims, but also to protect the rights, the narrative and the story of victims of these convicted sex offenders in the past. The other right to be forgotten is in terms of sex offenders changing their names through deed poll. And we have had quite extensive reports in the United Kingdom where the use of deed polls has been abused in order for registered sex offenders to change their names, not inform the police authorities there or on Garda Síochána here, and go under the radar again. And registered sex offenders, while in this legislation and in the current legislation, are required to notify the Gardaí within 7 days at the moment, 3 days after this law is enacted, of a change in name. The onus is on the sex offender to report that change in information. And that, as we know, does not work today. At the moment, sex offenders are supposed to inform on Garda Síochána of their address within 7 days and any subsequent change to that within 7 days. And as we know, we have breach after breach, week after week, of that very basic condition that is left out there at the moment. And as a result of that, people are literally disappearing off the radar, changing their names by deed poll, not informing on Garda Síochána. And I know in the UK, sex offenders registers have in many instances changed their names without informing officials, and that it is quite common for this to happen. And I suspect the same is the case here in Ireland. And Sky News, in a report, found numerous cases in the British courts where names had been changed, but the individuals were the same as the ones that had carried out similar offences previously. And the report goes on to talk about the case of Terry Price, who conducted a string of sexual offences over 3 decades and had changed his name 5 times in an effort to cover up his recurring pattern of behaviour. Price was even allowed to change his name while he was in prison. And Minister, we need to ensure that this law is amended to protect the victims and ensure that the perpetrators of these crimes do not have the right to be forgotten, do not have the right to change their name, do not have the right to try and circumvent the sex offenders register as they have consistently done up to now. I want to come back again to the issue of disclosure, Minister. And it's great to see the change in mind regarding the principle of disclosure. And this is very, very significant that it's being put onto our statutes and into legislation for the first time. I'm concerned that it doesn't go far enough. As you know, I published a bill in 2012, which was accepted here at second stage in 2013, which provided for far more extensive disclosure, but at the same time balance the rights between parents and those that are protecting children and the rights of the convicted offender. And I hope that during committee stage of this legislation that you will actually revisit the wording that I proposed back in 2012. And if I go to the situation in the UK where they have the right to disclose to the public for a considerable period of time. Disclosures about registered child sex offenders were made in just 7% of cases, directly impacting on 60 children. But what was more interesting was the fact that it also led to other actions, including referrals to the Children's Social Care Services in 27% of cases. And the British Home Office research suggested that the police and the other criminal justice agencies had seen benefits in the formalisation of the process, which led to the provision of increased intelligence and the provision of a better route for the public to make inquiries about their concerns. And we do need in this country to change the attitude in relation to reporting suspicious activity. We as a population are slow to report our concerns to An Garda Síochána, and we leave it to someone else. But sometimes this decision has devastating consequences for victims, and sadly, in many instances, we're talking about children here. I'm going to give you 3 examples of what I'm talking about, Minister. And this is going back, and I've put this on the record previously, but I'm going to revisit it here today. There were 3 incidents in counties Louth and Dublin involving strangers approaching children on both streets and at a playground. And it highlights the need for us to look again at what type of disclosure we're prepared to introduce. In the first case in Dunleer in County Louth, a stranger pulled alongside a playground and called out a boy's name as he played with friends. In another incident, in Monaster Boyce, again in County Louth, a man in a van called out to children on a Sunday afternoon. There was a third case then where Gardaí were investigating a case in Lansdowne Road in Dublin from the previous month, where a 10 and 11-year-old boy were approached by a stranger driving a black car, but it was only reported to the Gardaí sometime later. And what this does is it exposes that lack of reporting of suspicious activity. In relation to the Dunleer incident, the individual in question had to have done some preparatory work in obtaining details about that particular child. The question is, did these inquiries not raise a suspicion at an earlier stage, and why were they not acted upon? In the Dublin incident, it took 10 days for that incident to be reported to An Garda Síochána. Now, Minister, we need to send out a clear message to the public that they should report all suspicious activity, and the best way to do that is by encouraging parents to report such suspicious activity on the basis of giving the Gardaí the right, under certain limited circumstances, to disclose relevant information to parents. And I believe that it is important that we do look at the wording in relation to this legislation regarding disclosure. The final just point that I want to make, Minister, the work that I've put into having this legislation published and hopefully enacted is down to the efforts of one individual, and that was now retired Sergeant John Hines, who was based in Castlerea, Mayo man, who was based in Castlerea in County Roscommon. And I want to publicly acknowledge his work in trying to progress this particular piece of legislation, because John is an individual within An Garda Síochána who was so frustrated with the lack of progress in dealing with the anomalies within the current legislation. The man that was actually responsible for enforcing and monitoring these sex offenders, that he spoke out in relation to it and pointed out the weaknesses within the legislation. And there is absolutely no doubt about it that in my part of the country and many parts of the west of Ireland, there are individuals who are convicted, some of whom are in prison today, who would never have been put in prison, would never have been convicted, were it not for the Trojan efforts of the now retired Sergeant John Hines. And not just in relation to his own day-to-day work, but the provision of advice that he provided to Garda colleagues throughout the region, and the support, as I say, that he provided to me in helping to progress my primary legislation back in 2012, and the efforts that I've taken since that to try and bring this legislation about, to reform the laws in this area. And I look forward to working with you, Minister, over the coming weeks, and hopefully it would be great to see an early Christmas present to actually see this legislation enacted before the end of this year. Go raibh míle maith agat.